Thank you. We will call now our matter scheduled for hearing at 10:15. I'll just shift my piles here. And that is the case of Kyle versus Kyle. I'd ask counsel to state their appearances for the record.
Your Honors, Kristen Gertie on behalf of the appellant Glenn Kyle.
Good morning, Your Honors. Cameron Cutler and Benjamin Mills on behalf of the appellee, Ms. Holcomb.
E.J. Overson, private guardian ad litem at the trial court level.
And who'll be making the argument?
I will, Your Honor.
And you won't be arguing, but are available should we have questions.
Correct, Your Honor. I chose not to file a brief, and so I'm merely here in case the court has any questions, but I don't intend to argue unless the court requires it.
Very good. We allow 15 minutes aside for oral argument. Ms. Gertie, you've apparently already let our clerk know that you'll be saving 3 minutes for rebuttal. The other thing I would mention is that we live stream and record our proceedings, so don't stray too far from the microphone or it won't be picked up. And if we have occasion to listen to the arguments later, we won't hear some of what you had to say. If you're in the middle of answering one of our questions when time expires, just please go ahead and answer the question. You don't need to ask for permission to stay at the podium, but when that answer is completed, then it is time to sit down if you're looking at all zeros on the clock. With those preliminaries out of the way, then we'll hear from appellant.
Thank you, Your Honors. I'd like to make 4 points this morning. First, under Utah Code Section 81-6-208-10D, imperfect notice is not absolute forfeiture and does not support on its own the lower court's ruling. Second, the district court's reliance on latches was legal error as it was not pled and there were no prejudice findings by the lower court. Third, even without latches, total forfeiture was an abuse of discretion based on mother's actual knowledge and agreement with the amounts owed. And finally, the attorney fees award must be reversed because there was clear reservation of rights and because father's enforcement motion was colorable as a matter of law.
Can I ask you a question? And
Yeah.
I don't, this is not a gotcha question, or I don't mean to be too personal, but do you have a conflict of interest in appearing here in the Court of Appeals when you were involved in the proceedings below?
I don't believe so. The court below did address the attorney witness rule under the rules of professional conduct. And that was brought up by mother's attorney at the hearing. And the court decided that there was no conflict because it was clear to the court, number one, that I was not acting as counsel in the trial court. And that as a witness, he could distinguish between when I was acting as a witness in the case and when I was acting not as counsel. In this case, because we are not arguing any factual conclusions, we're not appealing any of the district court's factual conclusions. I don't believe that there is a conflict of interest because the credibility or the factual findings that the lower court might have made with regard to any of the testimony, mine included, is not before this court.
Okay.
But
Thank you.
if,
I
but
just
if
wanted
you
to clarify.
prevail in the appeal, one of the things you're asking for is vacature and for the proceedings to be a do-over, basically, right? So you might be a witness again?
Potentially. This court could actually reverse without remanding. Because there are no facts in question, because mother has admitted and agreed to the amounts in question, there is no question.
Well, I'm sorry, I was distracted by your brief, which said you request vacature of the fee award.
Of the
and-
fee award.
And remand for proper adjudication, ensuring access to evidence and adequate preparation.
If
time.
necessary, and that is with regard to the continuance and the issues that deal with the affidavit. My testimony had nothing to do with the affidavit. It only had to do, and would have to do, with the medical expense issue, which we are asking simply for the court to reverse. So I wouldn't be a witness at that point.
Okay.
Tell me about your actual knowledge on
The actual
mother's
knowledge argument?
part, because it seems to me that whether the court had in mind actual latches or just a notion of undue delay, sort of using the term latches casually rather than precisely, the trial court had in mind that there was undue delay on the part of your client in requesting reimbursement of the medical fees. Seems a strange path to go down if it was clear that there was actual knowledge on mother's part of the expenses.
Yes. Well, first off, the court did not make any findings regarding the facts of when mother did or did not have notice, other than to simply say generically, mother had no notice. But what is in the record is that in 2022, January and February of 2022, father was paying child support at that point. And the Office of Recovery Services was crediting him the medical insurance portion, and mother knew that her child support was being lessened by the amount of the medical insurance premium. In March of 2022, what changed was simply the mechanism by which that reimbursement was happening. In March of 2022, father had sole physical and legal custody of one of the 3 minor children, had for over a year, and at this point now, he's had sole physical legal custody for over a year, and the parties have joint 50-50 legal custody of the other 2 minor children. Father stops paying child support at that point. So at that point now, mother has to affirmatively pay her half of the medical insurance.
Aren't there expenses an issue other than just payment of the medical premiums?
There are, and for those, she also had actual notice, and in the record, it shows that she had notice of both some contact lenses and some braces, and her argument in the transcript and what the court found was not that she didn't have notice of those, but with regard to the contact lenses, she found, in her words, it was a wash with some of the expenses that she had incurred. With regard to the braces, her argument wasn't that she didn't have notice, but that she didn't believe that they were medically necessary, because a few years before, she had gone to an orthodontist with the child, and Medicaid had declared that the braces at that point were not medically necessary. And so she chose not to be involved in paying for them, not because she didn't have notice, but because she didn't feel that they were medically necessary. In other words, she didn't agree with them. She was shown, and it is shown on, and I've got the exact record page, but it's shown in the record on page 62, line 19. Mother was asked specifically by the court, and the court reinforces that she had seen the exhibit that was admitted by the court that had all of the medical expenses. She was asked if she agreed with those expenses, and she said yes. Note that she did not say, I don't know, I've never seen these expenses. These expenses are new to me. I didn't have notice of them. What she said was, yes, I agree with those expenses. So with regard to the medical insurance, the court abused its discretion in 2022 by wiping out March through December's reimbursement simply for no stated reason. The overall reason that mother didn't get notice, but mother would have had notice because the Office of Recovery Services had notice in January, which is what is required under 81-6-208.
So doesn't that suggest the court just completely ignored her testimony that she had seen the exhibit setting forth the expenses and agreed that she owed her part?
It does, which is an abuse of discretion. And which gets me back to the first point that I wanted to make, which is that notice or failure of notice alone is not sufficient to dismiss.
What if at a trial court, you've got the statute and you've also got the decree, what if the trial court kind of foresees this? Wouldn't it be shocking to me that a trial court might say, you know, one of the things I don't want to deal with in the future is the accumulation of expenses, notice or not. I don't care about that. What I care about is that they suddenly accumulate and then I get an enforcement action saying I want to pay them, and then we get into a big court proceeding. What I'm gonna do is I'm gonna impose something that says within 30 days of the incurrence of an expense, notice or not, you've got to request reimbursement. And if you don't, I'm not gonna award it. Can a court do that?
I think the court could do that, but the court has to do that before imposing that limitation. What happened here is that the judge makes a point to the father that you did not give notice of your monthly insurance expenses. He makes that point on, it's when he is talking to Mr. Windsor, father's counsel, he says, well, if we put father back up on the stand, Mr. Brindley, the attorney for mother, would simply ask, did you give notice of mother's knowledge of the monthly child insurance premiums? Bottom of page 79 going up to the top of page 80 of the transcript. And the answer to that would be no. The problem here is that the judge seems to be adding a new requirement that the parties had no knowledge of. Could they do so? Could he do so, Judge Mortensen, for the future? I think he could. But he can't impose a restriction or a notice requirement that the parties have no knowledge of. And under Davis versus Davis, this court's precedent makes it very clear that the notice obligation under section 208.10 and the reimbursement obligation are not mutually dependent. They are, as this court said, independent obligations. And verification or notice is not a condition precedent to the reimbursement. Now, the court can, and
I
it's,
see that with respect to the premiums for medical insurance, which are pretty objectively ascertained. But with respect to those expenses not covered by insurance, it seems like the parent who knows about them, as just a matter of basic fairness, should say, okay, here's some more. Your half is thus and so. It doesn't seem like that's as automatic as the insurance premiums.
absolutely, and I would agree with that. And that's where the court's reliance on latches as its only stated rationale for denying reimbursement is essential for this court to look at. The court doesn't say, I'm looking at the circumstances, and because you didn't give notice of these particular things, it was a prejudice to mother. It was unfair because she didn't know. What he says was, I've decided that the reason that I'm denying this is because of latches. And then he
You're
goes
saying
on,
that's the sole reason.
that's the sole stated reason in this record.
So if we look at the record and there's another reason, then that argument would fail.
And that is the only reason that Mother's Counsel has argued here, is that It actually argues that latches is an alternative basis, and it says that notice is the basis. But notice can't be the basis, because under 20810D, notice is just simply a trigger for the court's discretion. And so the court has to exercise its discretion. And the way that you can read this kind of strange interaction that happened in the court is that the court, as soon as he says there's no notice, the court immediately says, and I find latches. I find that all of the elements of latches are met.
The court doesn't say all of the elements of latches.
He
The
says,
court, the court sua sponte invokes latches, and that
Yes.
is problematic, because latches is an affirmative
it's an affirmative defense that under Rule 8 has to be pled.
That's where I got the idea that maybe the court is just using that term kind of loosely and not in its term of art sense, as having in mind just basic delay, because the court does not tick off the various requirements of latches. You identify prejudice as one of them, but
And then undue unexplained delay. And that's all he talks about. Never anywhere does he articulate any, and neither does Mother's Counsel, articulate any prejudice that has happened because of the delay. And we'll reserve the rest of our time for rebuttal.
very good. We'll hear from you on rebuttal, and we'll turn our attention to Appellee's argument.
Good morning, Your Honors. Each of the district court's rulings in denying Mr. Kyle's motions to enforce should be affirmed. To begin, I'll highlight one particular finding and sentiment of the district court that we agree with. In regard to Mr. Kyle's motion for reimbursement of medical expenses and the district court's decision to grant Ms. Holcomb $5,000 in attorney's fees, the district court said it's not a hard issue. And it isn't a hard issue. And none of the issues before you are. In regard to medical expenses, the district court received evidence, factual testimony from Mrs. Holcomb, and accepted her unequivocal testimony that she didn't receive notice of any medical expenses or the insurance premiums before Mr. Kyle filed his motion to enforce. And on appeal, Mr. Kyle has not adequately addressed and rebutted that independent foundational ruling. Affirmance is the correct and it's the straightforward conclusion. Now, I'm here today to be of service to you. And so I'm happy to answer any questions that you have on any of the issues raised in the briefing or in Ms. Kyle's initial argument in whatever order you prefer.
Can you address the argument that at trial, Mother said she had seen the exhibit before, setting forth the expenses, and she agreed that she owed her part of that? Is that not an accurate characterization of what happened?
Yeah, I think some clarification on that as far as the timing and chronology is important. Mother's testimony was that she never saw those reimbursement exhibits before the motion to enforce was filed. Now, a year had passed in between the filing of that motion and the evidentiary hearing. And so Mother testifying, that within that year between filing the motion and then giving testimony, that she had seen the exhibits supporting the motion, and she was acknowledging, yes, these appear to be medical expenses, and I don't have a basis, I'm not contesting whether or not these were actually paid. That makes perfect sense, and that's in no way in conflict with her testimony that the court accepted, which is she didn't have notice before the motion was filed.
Didn't have notice in timely fashion.
Yes, exactly.
Do you agree, or what's your opinion? Do you tend to sort of characterize the district court's latches ruling? I mean, it was really a sua sponte, like no latches. Was that intended as more of, well, we're gonna deal with the lack of notice and the lack of, and the time that's passed, since that motion to enforce was filed. I mean, was the court undertaking an actual latches analysis, which is an affirmative defense, which was never pled?
Yeah, yes, our position is we have two independent rulings, and I think that's clear from what the judge says. If you look in particular just at one of the statements that was made in the oral ruling, and it was again confirmed in the written order, the court says, the court finds there was no notice of the expenses given to Ms. Holcomb, but even if there had been, the principle of laches applies. So even if there had been, indicates two separate rulings, that's synonymous with alternatively. And that statement alone makes it clear that notice was not the underlying satisfaction of the elements or the basis for a laches finding, because the court wouldn't have said, even if you'd given notice, I'm still finding that laches is satisfied. Now, as far as the laches ruling, yes, I don't think it was clearly and in those terms raised by either of the parties. What the court did say in his ruling is he said, well, this is akin to waiver. And essentially what Mothers argued is waiver and no notice. But yet the laches ruling is no model of clarity for certain. I think in the written and oral rulings, you have evidentiary and factual findings that could support either of the two elements of laches, but that is not succinctly delineated or articulated. I find laches, the two elements of laches are unreasonable delay and prejudice to the other party. In regard to unreasonable delay, here is how I find. In regard to prejudice, here is how I find. We don't have that in the orders, Your Honor.
And I follow that logic. On the other hand, it doesn't seem to me completely harebrained for the other side to say, you know, in the decree, we were obligated to share the cost of medical insurance and the cost of those expenses not covered by medical insurance. And so father brings a claim, and maybe it's too late, and maybe he should have asserted it sooner, but if under the decree he's entitled to some reimbursement, it doesn't seem to me just the epitome of bad faith and maliciousness to assert an entitlement to that reimbursement. So I'm shifting you to the attorney's fees question. Even if I buy your argument, even if we buy your argument about either laches or delay, it seems like father's assertion of his right to reimbursement is not so far beyond the pale that this just is clearly a bad faith assertion of a claim that merits an award of attorney's fees. That's more of a comment than a question, I recognize, but tell me what's wrong with that perspective.
I don't think there's anything wrong with that perspective, Your Honor. I think here we have multiple statutory or independent bases to grant attorney's fees. And I think what you're referencing, Your Honor, is the bad faith statute.
Which is what the court seemed to have had in mind.
I think that it is equally possible that the court had in mind what I think is the more readily apparent statute, which is the child support enforcement statute, which is, and I can give you.
Which is basically a loser pays statute.
Yeah, if you substantially prevail and it's on a motion to enforce a child support order, the substantially prevailing party, the court may award attorney's fees. And what matters there is it's attorney's fees. The statute doesn't require or say anything about reasonableness of attorney's fees.
Oh, come on. We could don't we fairly infer the term reasonable left, right, and center on everything we do?
I don't think so, Your Honor, because.
Everything we do with respect to attorney's fees.
Yeah.
Well, I'd say it matters that the legislature, in multiple spots, we have many statutes that deal with attorney's fees. And there's some that say reasonable attorney's fees, like the bad faith statute.
Right.
And there's others that say here, the child support statute says attorney's fees. I mean, we presume that the omission of any term or the inclusion of any term by the legislature in drafting a statute, it's advisedly, it's intentionally. And so I don't think it's appropriate when that term is omitted to presume that you can replace it and put it in when the legislature certainly knows how to write that term into a statute.
So let me, and I'm sorry if I interrupted you, but I think, coming back to my observation, that what the court seems to have had in mind was the bad faith statute. The court referred to father's petition as being frivolous, a complete waste of time. Those are two examples that I jotted in my notes. He said some other things that were not especially charitable about father's claim. Is what you're suggesting is, okay, that may or may not fly, but if it doesn't, you should affirm on the alternative basis apparent in the record, namely, that mother was entitled to recover those fees under the child support enforcement statute.
Yeah, that's exactly right. I think there is sufficient findings, and there is a basis that the court was there and observed Mr. Kyle and Miss Kyle as witnesses. It could determine, based on the evidence before it, subjective intent. And there's enough there, and I think the statements do support a finding of bad faith. But even if not, if you don't accept that, clear on the record is the child support statute that provides Miss Holcomb substantially prevailed. She's entitled to her fees under that statute as well. And to further, when we talked about the statute and do we read reasonableness or not, whether or not it's there, there is a case actually from this court that makes it explicit that when it comes to that particular statute, it's the Gore versus Grant case. We cite it in our brief, 2015 Utah App 113. Under the child support statute, when we're looking at fees, the usual attorney fee factors do not apply, including the reasonableness of the requested award or fee.
Gosh, I hope I didn't write that opinion.
I know I
I'm
did.
pretty sure I was on that case. Because it's Horace Grant. Oh, hell.
On the other hand, the court awarded you 50% of the fees you requested. So you're not arguing that the award was unreasonable, in fact, right? Wasn't the request for 10,000 and the court awarded 5?
No, I don't think that's what, I think what happened on the record, Your Honor, is the court asked for evidence and made a determination of the total amount of fees. Simply asked trial counsel, who was under oath, whether $10,000 in fees or more had been expended, and then allocated and made a determination that at least half of that, 5,000 of those fees, could be fairly allocated and attributed to the medical expense issue. So I don't think there was a request for 10,000 or more. It was just an apportionment to the portion that the trial court.
So the trial court threw out the $10,000 figure. It was at least 10,000. Counsel agrees, okay, I'll give you 5. Your position would not be that we can sustain that only if we're willing to cross this hurdle that an award of unreasonable attorney's fees is okay under the statute. I assume your first line of defense is, under the circumstances of this case, awarding half of what at least had been spent, $5,000, that's abundantly reasonable.
Absolutely, Your Honor. And you have evidence on the record, sworn testimony from the attorney who incurred or charged those fees, that it was at least $5,000. And if we look at the amount of work done here, a motion supported by evidence and then a full evidentiary hearing, I think my clients would be thrilled if I could cover that in $5,000 or less. So if we stay on the fee issue, a couple points, I think it's addressed well in the briefing. But the fee certainly was reasonable. It's supported by the evidence. You have our argument in hand regarding the child support statute not requiring that determination at all. On top of that, the issue on payment of fees and that the appeal is moot to begin with. Those fees have been paid. And I think it's important to note how they were paid. They were paid directly to Mr. Brindley, who's no longer counsel of record for Ms. Holcomb, but was trial counsel below. And as we specified in our briefing, there is no statement of intent in the record indicating the intent to preserve.
Were they paid post notice of appeal?
Yes, I believe that some of those payments happen post notice of appeal, but that often happens. We know the general rule is voluntary payment of a fee award or a judgment can moot a pending appeal. I think it's naturally presumed that in most cases, you have a notice of appeal, you have an ongoing appeal, and then payment occurs. And so it's
typically,
immaterial.
If you want to preserve your right to appeal, you would expressly reserve your rights. This payment is made under protest in full reservation of my right to appeal this issue, and we don't have that in our record, do we?
Exactly, that's exactly right, Your Honor. We don't, it's not in the notice of appeal, which is very generic, general. It's an appeal of the entire order. It says nothing about attorney's fees. It's not in the objection that came long before in front of the trial court. That's just a general objection to fees without any kind of indication of a preservation of rights on appeal. The other things that are mentioned are a docketing statement. The docketing statement is not in the record, and it's not a statement on the record. And neither is any statement that would have been made in mediation. That's not in the record, nor could it ever become a part of the record, because those are confidential statements. They're not admissible, they're not discoverable under the Utah Mediation Act or under Rule 408. I'm out of time, and so unless you have other questions, I will sit down.
Apparently, there are no other questions. Thank you. We will hear 3 minutes of rebuttal, up to 3 minutes of rebuttal.
All right, a couple of points on rebuttal. First, with regard to attorney's fees. The Gore case makes it very clear that fees must be based on evidence and supported by findings of fact sufficient for appellate review.
Didn't the trial court invite further examination at the
No.
hearing?
The court invited an objection. The court then took the objection, said, I'm going to cover my bases by putting father's and mother's attorney under oath, asking one question, which was, well, I guess it's a two-part question. Did you spend $10,000 worth of time on this case? And can you attribute $5,000 of it to this part of the case? Father's attorney objected as he was instructed, would have objected more, but as soon as the court said, thank you, it was very clear that the judge was going to hear no more.
So you're saying no further objection or argument needed to be made under futility, that it was clearly futile?
It was clearly futile. The court earlier, when father's attorney was trying to put on the record his argument that notice alone was insufficient and that there was the discretionary trigger, was told, it's time to stop. Don't dig any deeper. It was very clear from early in this hearing that the judge was not going to entertain any further argument from Mr. Windsor. And so when it came to the attorney's fees, and the judge said, I'm not going to require the affidavit that would be required under Rule 73. And when he knew that the specific findings that are required by Gore versus Grant from this court were not going to be made, he objected. But that's all he could do. He couldn't do any more because the court was done. This also really should not be and cannot be recast as prevailing party fees. It is true that father's motions to enforce were denied with regard to contempt for mother. But father gained relief on numerous, at least 2 of the motions that were before the court. With regard to therapy, both individual and conjoint. For the daughter, HK, mother was ordered to participate in that therapy, to have the daughter there and to have those appointments scheduled. That was prevailing party relief, despite the fact that the court did not hold mother in contempt. The same thing is true with the motion for communication. Mother was ordered to allow the child, JK, to have his phone at her home. That, despite the fact that the court did not hold her in contempt, was prevailing party for the father. It would be nonsensical to say that mother was given prevailing party attorney's fees for one portion of an award, but father didn't receive any prevailing party fees for the parts of the motions that he prevailed on. Therefore, the court should reverse and reimburse Mr. Kyle for the amount of the attorney's fees, because the court did state that that his motion was frivolous, meritless, and in bad faith.
And in making the payment that he did, he reserved his rights.
He did. Mr. Kyle, his attorney objected to both the basis and the amount of the fees in the trial court. He put in his notice of appeal that he was appealing the entirety of the court's order, which under the precedent of this court, unless you have specified particular issues to be on appeal, it is understood that all issues are on appeal.
But the check didn't have a restrictive endorsement or wasn't
The
accompanied
check didn't
by
have a restrictive endorsement, but there were specific conversations with Mr. Brindley and with Mrs. Kyle, Mrs. Holcomb, that we were going to appeal the fees.
Is that in the record?
It is not in the record. The right is in the record is the notice of appeal. That is in the notice of appeal. And then as far as paying them directly to Mr. Brindley, there is record, again, not in the court record, but there are records that show from Mr. Brindley, between Mr. Brindley and Mr. Windsor, that Ms. Kyle or Ms. Holcomb specifically instructed Mr. Kyle to pay Mr. Brindley.
You understand we can't consider things that.
I understand that. But since they made a point about the fact that the fees were paid directly to Mr. Brindley, I wanted to let you know what the actual facts were, because that's not in the record either. So,
Okay,
Thank you,
thank you.
Counsel.
We will take the matter under advisement and let you have our written decision as soon as we're able to get that taken care of. With that, we will be in recess, I believe, until Thursday.